Good morning. Today's presentation is going to be an overview of federal Indian law, some of the major policies that have impacted tribal communities, and tribal real estate. There's a lot of material to cover, and within the PowerPoint there are references to case law and major legislative policy. So when the conference is over, if you have further questions, please reference the PowerPoint slides and you'll be able to find more information. What we are going to cover today are some of the founding principles to consider when researching and working on issues in Indian country. We're going to cover briefly the 500 years of federal Indian policy in about 45 minutes. So it's going to be a quick lesson today. But then we'll go over what are some of the key concepts of federal Indian law, a little bit about tribal governments, their jurisdiction, and some issues with tribal real estate. So I think one thing to keep in mind when you're working in Indian country is the importance and the concepts of the community and that it still exists today, and that some of these concepts about the connection to the community and the connection with family and traditions are still some founding principles that impact tribal communities and that guide tribal communities. So here's a quote from a tribal member from LCO, and a lot of these principles still exist today, should be considered when working in Indian country. Some of these principles come from a theory of the first treaty. And under that theory, Indigenous nations have origin stories which relate back to the creation of Earth and humans' connection to the world. And this basis forms an understanding for a tribal nation's relationship with its land. And under this principle of the first treaty, Indigenous communities and people were placed in the earth and given the legal and moral obligation to manage land in a way that was going to honor creation and balance within the world. So the philosophy of this first treaty still remains in existence today, and it's a controlling principle in all relations within property within Indian country. So when we recognize that this principle still exists, that these Indigenous peoples and tribal nations were placed on Earth to manage the land and to manage the resources, and that's the first obligation, then you'll have a good founding basis to move forward with real estate transactions and issues in Indian country. So jumping back, federal Indian law predates the United States policy, and when we're looking back at first contact, that came about because of European exploration and European nations' desire to conquer and control lands. And those disputes between the European nations' desire for land and Indigenous nations' management of the land caused conflict. And so Indigenous nations entered into treaties with these European nations in order to resolve these disputes. And through those treaties, they were resolving the issues around use and control of the land. So this established the first political relationship, and it viewed Indigenous nations as sovereign governments entering into a government-to-government relationship with these European nations. So that then led to the Colonial period. And the European conquest continued into the Americas as the area was being settled. And England's control of the area was being challenged. So again, treaties were being used to build relations, to build alliances that would be beneficial during different wars, and then to settle disputes over some of those land battles. England had attempted to control the political relationship with the Indigenous nations, which England then believed would allow them greater control of the land. And you can see King George III issued a proclamation which prohibited further encroachment on tribal land And this is the first proclamation where they started to define Indian country. So then we move on to the Confederation period. And this is now when you have several European and immigrant communities establishing in the United States, or the pre-United States. They're now wanting to separate and form their own government. So within this period, they were recognizing the tribal affairs and the treaties that existed. And they realized they needed to address this during this Confederation period and the formation of the United States government. And so it was one of the key priorities. And the framers of the United States addressed the relationship with indigenous nations in several of these documents. One of the key pieces being the Constitution. Within the Constitution, the framers placed Indian affairs as issues that were going to be within the subject matter and jurisdiction of Congress. And this was, again, continuing with the practice of that political government relationship between indigenous and foreign nations. So here we see the United States taking the position that England and Europe's position was on Indian affairs and adopting that same philosophy of having that government-to-government relationship and recognizing the sovereign-to-sovereign political relationship. So within the US Constitution, there are three main pieces that recognize this tribal relationship. Article 1, Section 8 is the Commerce Clause. And within that clause, it says Congress shall regulate commerce with foreign nations and with Indian tribes. So there you've got your first position setting up Congress with the authority to deal with tribal governments. Article 2, Section 2 is the Treaty Clause, which authorized the President of the United States to enter into treaties with the consent of the Senate. And then Article 6 has the Supremacy Clause, which recognized that treaties are the supreme law of the land. This was recently upheld in a United States Supreme Court case, McGritt, out of Oklahoma, which recognized the boundaries that were established in treaty with the treaty there in the, I believe it was the Creek Nation. So next we have the Trade and Intercourse Era, which was from 1789 to 1825. And in here, during this era, President Washington and Secretary of State, or Secretary of War Henry Knox and Secretary of State Thomas Jefferson were working through some different policies on how to manage the relationship between the United States government and tribal nations. And they understood the sovereign political relationship, and they respected that. In one letter to Washington, Secretary of War Henry Knox had stated that the independent tribes of Indians ought to be considered as foreign nations, not as the subjects of a particular state. So here they understood the concept of sovereignty of tribal nations. You can see some of the federal acts that were being passed at this time, also recognizing the responsibility to manage those relationships. For instance, starting in 1790, there were Trade and Intercourse Acts, and those acts are still in existence today. And within the Trade and Intercourse Acts, there is language in there that prohibits the purchase and encumbrance of alienation of Indian lands without the consent of Congress. And so still to this day, if tribes are looking to convey their Indian lands, they have to seek BIA approval when engaging in those activities. So by the end of this era, around 1871, at that point, the United States had negotiated and ratified 391 treaties with American Indian tribes. But after that time, it was viewed as no longer the policy that was controlling the relationship with between the federal government and American Indian tribes. So then we go to the removal era. And this was a harsh policy that was led by President Jackson, but it was fully supported by Congress. And under this policy, the concept was to acquire more lands for settlement, and then in order to do so, they had to remove tribal communities from their current lands. One idea was to relocate everyone into a specific Indian territory, which is now set up as Oklahoma. So there is a very large tribal presence in Oklahoma. But during this time, many tribes had moved west under agreements that they had entered into with the U.S. government under treaties. And part of this was their cession of lands, and then in return, they were getting promises of protection and promises to be settled in their land without further encroachment, and additional promises of annuities and supplies to help them with survival in their new communities. These policies were reviewed in one of the seminal series of cases, the Marshall Trilogy. So under the Marshall Trilogy, some of the policies were being challenged in court regarding the relationship between federal Indian tribes and the tribal government, and the United States government. Justice Marshall wrote the first of a series of opinions, the first one in Johnson v. McIntosh. And that was a case that looked at the status of Indian lands. And in that case, Justice Marshall set forth the discovery doctrine. And that was a doctrine that he had adopted from European nations. And under that policy, they viewed tribal land from a conquest theory, that under this theory, they ignored the indigenous communal land use and found that these European conquering nations then had ownership of the land, and tribes did not have the full bundle of sticks that you would consider with fee simple absolute title. After the conquering or discovering nation had stepped in, they then had title to the land. The next case was Cherokee Nation v. Georgia. And in that case, Justice Marshall found that tribes being located within the United States were domestic dependent nations. And because of their unique status within the U.S. and the treaty relationships, they had the right to occupy their land, but it was subject to federal action. And this is what created the first of the first principle of the trust relationship. Their unique location within the United States and the relationship under treaties created that trust between tribal governments and the United States. The next case was Worcester v. Georgia, which found that state laws don't apply within tribal territories, that the tribes are independent political communities, and they still retained their authority to govern within their tribal boundaries, and that states did not have the ability to encroach and govern and impose their laws within tribal reservations. So during the Reservation Era, there was the policy to separate tribal governments from the American settlers. And the thought was that this would resolve some of the conflicts and the battles over land. And originally, some of these reservations were set up with large areas, large tracts of land for these reservation communities. For example, there was one reservation, the Great Sioux Reservation was set up and was going to incorporate all of South Dakota and parts of Nebraska, Wyoming, Montana, and North Dakota. And again, as I mentioned, Oklahoma was going to be set up as Indian Territory. But this was an impractical philosophy. And as they were finding, there was a desire for more land from the settlers. And so reservation boundaries were sometimes changed. And they also found that they wanted more management and control within the reservations. So the U.S. government would set Indian agents out to live within the reservations and also give stipends and stipulations to churches for them to come provide financial support and operate missions and schools within the reservation era. And so all of this was to help manage reservations, to help distribute treaty payments and provisions, which again were promised under treaties. So you had those 391 tribes set up, 391 tribes that had entered into treaties with the United States government. After the reservation era, the churches and the Indian agents were implementing some of the policy that was in place from the U.S. government. But from the U.S. government's point of view, the Indian problem still existed. So then we enter the boarding school era. And under this concept, the U.S. government believed that if they removed the children and sent them to boarding schools, then they could further Christianize and civilize the children. And then that would spread into the rest of the community and help resolve this Indian problem. So Carlisle, here's a picture of students outside Carlisle Indian Boarding School, which was out in Pennsylvania. And you can see just large groups of children all dressed the same. When kids were sent to boarding schools, it was a very harsh reality. Many children were beat if they spoke their language or if they practiced their cultures or religion. When they went to boarding school, their belongings were removed from them and their hair was cut. They were, the concept of the boarding school was to make all of these children look the same and to be assimilated into U.S. culture. And Richard Pratt was the leader of Carlisle, and in a letter he wrote that in a sense that all the Indian is a race that should be dead. Essentially, he said that to kill the Indian in him and save the man was the concept of the boarding schools. So with the boarding schools, then there was also the allotment and assimilation area. And one of the main federal legislation acts that was passed was the General Allotment Act. And this act allowed, created a system where reservation land was going to be cut up and delegated out to individual family members. And they would then go away from that communal style of reservation living and have their own independent tract of land. And the goal was for them to adopt this farming lifestyle. So reservations were checkerboarded up, individual families selected different lots of land, and they were no longer allowed to live in this communal lifestyle. After tribal members selected their allotment on the reservation, then the remaining land was divided up and opened up for sale to other U.S. and European settlers. And this policy then resulted in a loss of large amounts of tribal lands. In 1871, there was 138 million acres of tribal land. But then by 1934, at the end of the policy, we're down to 48 million acres. And within a lot of these tribal lands, tribal members weren't often given the opportunity to select good tracts of land because reservations were set out in desert areas, areas with low water. And so you had a lot of allotments where there wasn't the possibility to set up a farming lifestyle, and the land wasn't capable of producing that. So you can see here an example of some of the advertisements of when land was being opened up on reservations. And within this advertisement here, Wisconsin is listed. And within Wisconsin, they are reporting that in the year 1910, over 1 million acres of tribal land was sold. And each acre went at a price of $17. And that's of the lower value lands of those listed within the states on this poster. So 1910, 1 million acres of tribal land was sold to outside of tribal and indigenous communities. So here's an example. This shows land cessions from 1778 to modern day near present. And if you just watch, you can see how originally the United States was all tribal territory. But then through treaties, through allotments, through various congressional acts, majority of that land was taken away, transferred out of Indian ownership to some of the red parcels that you see today. And even those have changed since this map was created. But it's just a harsh reality to see how that has happened over time. So then we come to the Indian Reorganization Act era. And in the 1920s, Congress was looking at the conditions of American Indians and tribal communities and reservations. And they found that there was really high rates of poverty and extremely poor health conditions. So they did some research, and there was a release of the Merriam Report to Congress, which in 1928 really identified and outlined the harsh conditions that American Indian communities were living in. So at this time, then President Roosevelt appointed John Collier to be the Commissioner of Indian Affairs. And they realized that the allotment policy was not working and had really just horrible effects on the living conditions of tribal communities. And so then in 1934, Congress passed the Indian Reorganization Act. And the Reorganization Act, the IRA, had several key pieces which had done some good things for tribes. So the IRA allowed tribes to set up tribal governments and also tribal businesses. The IRA also looked to further protect tribal lands. So there was some benefits that came through the IRA, but it really signaled a change in tribal policy. So that continued on for some years where there was some protections in place. But then we come to a new era of termination and relocation. So at this point, the United States wanted to discontinue the federal relationship with tribal nations. They really wanted to get a policy that would end the dependence of tribal communities on the United States, and they were looking to push tribal nations out and force them to be fully self-sufficient. So during this time, they repealed some portions of the IRA. They ended some of the tribal and federal relationships, and several tribes were terminated, including the Menominee Nation. With that, there was a disregard of treaty rights, and so those promises were no longer being upheld. And finally, to kind of further this separation, the federal government was delegating some of the responsibilities to uphold those promises from treaties to separate agencies within the United States government. And so those were kind of swallowed up and just assigned to the different agencies in the US government, and no longer a separate program until they started more programs with the BIA. During this time, there also was the relocation concept. And so under the relocation concept, they encouraged tribal members and individuals to move away from their tribal communities and go to larger urban areas where the thought was that there would be more opportunity for jobs, more opportunity for education, and independence. And so different programs were set up to encourage this transfer and this movement. However, those did not work, and a lot of tribal members just did not survive and thrive the way that the U.S. wanted them to when they were away from their tribal communities. So here we are, 1960s, and there has been a series of federal eras with lots of devastating effects, and a lot of disregard to tribal members' ideas and thoughts on how things should happen. But in the 1960s, we also have a lot of civil rights, and during this era, there was a lot of recognition of the American Indian movement and kind of the Red Power movement. So tribal members are becoming more vocal, and they're really advocating and fighting for their rights and the rights of other Indigenous people. And Congress is starting to listen and hear this and recognizing that there needs to be policies in place that have tribal input on them, and that tribes are going to be implementing. And so this is within that self-determination era. Congress passed a variety of different policies which really look to strengthen tribal communities and tribal governments. So you have the Indian Child Welfare Act was passed in the 70s, the Religious Freedom Act, Self-Determination Education Assistance Act. And so with this, they officially ended the termination and relocation policies and really emphasized the status as that tribal nations are sovereign nations on a government-to-government relationship with the United States and the federal government, and not in an equal position of states, but in kind of a higher position to have those relationships with the federal government. So we are still in a self-determination era, and tribes are really exercising their sovereignty and finding ways that they can regulate their communities and manage their communities and kind of exercise their self-determination. But from all these different eras, now we're going to transition and talk a little bit about some of these policies that still exist and how they've been implemented in the federal Indian law aspect to it. So first is the big key concept is the federal trust responsibility, which recognizes that government-to-government relationship between the tribes and the U.S. And this federal trust responsibility, as we mentioned earlier, stems from the Constitution and the 3 clauses that address relations with Indigenous tribal communities. It also stems from the treaty-making process. And within treaties, there often are specific clauses which outline the specific responsibilities that the U.S. government has to tribal nations. For instance, there may be clauses related to the provision of education for tribal communities, reserving rights in tribal communities. And so that creates that federal trust responsibility and the U.S.'s obligation to uphold those. And that trust responsibility has been affirmed over the years in various court cases. It's been recognized in executive orders and congressional legislation. And as we mentioned earlier, it was first recognized by the Marshall Trilogy where they were setting forth that policy of the trust relationship. So we're at a position today where there are 574 federally recognized tribes, and that number is changing as tribes are unfederally recognized tribes are petitioning for federal recognition. There's also state recognized tribes, which are tribes that may be in the process of seeking federal recognition. So throughout all of these different eras, federal Indian law has defined that what tribal powers still exist or when there have been limitations to them. And one key point is that tribes still have inherent tribal powers, and those include the right to establish its own form of government, the right to govern its members, rights to manage its land and their territory, and within that is the right to exclude others from their territory as well. We saw this recently with the Sturgis rally in South Dakota, where tribes there were putting up blockades, and because of COVID-19, prohibiting people from Sturgis from coming into their community because they did not want to see an increase in illness and a rise in cases in their community. So again, that's an exercise of tribes' inherent powers to manage their land and their right to exclude others from entering in their land and their territory. Tribes have also retained the power to tax, other powers to self-determination, education, and to just help their community and institute programs and services for the survival of their community. So there have been some limitations on these tribal powers. These tribal inherent powers are subject to congressional plenary power to limit their authority. And you do see different instances of Congress exercising its plenary power. And that comes about in treaties as the first example, where there are some limitations on what the tribes can do. And for instance, there's a cession of land, so tribes giving up certain areas of land that used to be their Aboriginal territory. You also see congressional acts divesting tribes of certain sovereignties and authority. However, any federal legislation that's seeking to adjust, to diminish or divest tribal reservation lands can only come from Congress, and it has to be a clear intent from Congress that they are specifically changing boundaries of reservation lands. So that's another instance where you see Congress may have acted to limit tribal powers. And again, there was in the U.S. Constitution, the Commerce Clause, which delegated to Congress the power to regulate commerce and affairs within Indian tribes. So other limitations on tribal power, there's kind of a general rule that you can consider when thinking about these issues. First, the state, again, is not on that government-to-government relationship. It is between tribes and the federal government. So the state generally is going to lack regulatory authority in Indian country and over the tribe. Again, Congress has that plenary power, and Congress has passed federal acts and statutes, which will then, in certain areas, preempt state law. For instance, there's the Violence Against Women Act, which talks about jurisdiction of domestic violence issues. That's a federal act, so that would preempt state legislation in that area. But there are times when states may show an interest and have the ability to regulate within Indian country. And the courts have upheld this area if the state can show an interest that it's sufficient and important in order to justify state regulation within Indian country. You see this within some taxation cases, specifically taxation of tobacco products, where a state may impose tobacco taxes and tribes may be required to collect that tax from non-member purchasers within reservation boundaries and transfer that to the state. So that has been considered a permissible state regulatory authority. But again, Congress has that plenary power, and they can also use that power not only to limit tribal powers, but to expand state authority to regulate within Indian country. That was done through Public Law 280, which was a transfer of criminal jurisdiction from, in certain states, from the federal government to state governments. The laws on criminal law in Indian country are fairly complex, and since the subject matter with this conference is real estate, we're not going to get into the criminal issues. But there is a considerable amount of legislation and case law out there outlining how criminal jurisdiction works out in Indian country. So again, we said tribes have the inherent authority to establish their own governments, and they have done so through various different means. Again, we mentioned the Indian Reorganization Act, which authorized tribes to form formal governments and provided a model type of constitution and model business charters. And many tribes did vote and adopt those type of tribal governments. So that's one way of a tribe has gone to formally establish a more, I guess, European tribal government. But yet some tribes still have adopted some of their traditional forms of governance into their governing structure. And you'll see those with more of a general council style structure. So now we're going to explore a little bit about the different structures of tribal government and kind of take a look at what those are. So again, there's the tribal government council style. Sometimes it's called Reservation Business Council, sometimes it's called Tribal Council, but it's a model where the authority of the tribe is vested within a board of tribal members that are elected from the membership. And that can include, it can be a small board, 3, it can be a larger board of 5 or 7, but the tribes usually identify what type of governing structure they're going to have within their constitution. And so within these structures, there is the ability to either have your chairperson or your secretary treasurer and your officers of the tribal council either voted on by the membership, and that's what you see at your tribal elections, where individuals will campaign and run for certain office positions, or to be just a member at large or a member of a certain district designated within the community. So that's one way of filling those board council positions. Another way is for individuals to vote or to run for election to be on that board. And then within that board, those executive officers or the executive officer positions are voted amongst the board. So they all take seat, and then during their first meeting as the tribal council, they vote in their officer positions amongst those individuals. And then under this model of tribal government, the programs and services are set up in a way of through a department structure, and those departments then report to the full board. And then the tribal board has the authority to act as a group together and can delegate duties and responsibilities to the specific departments. Another type of tribal government structure is a separation of powers government. This is very similar to the United States structure of government. In this type of system, there's a checks and balance of power. You have your legislative branch, which usually manages the Office of Management and Budget and finances for the tribe. They also pass laws, and often the legislative branch of the tribe will ratify executive action from the president or chair of the executive branch. So then your second branch of government is your executive branch, and that is usually run by a chief executive or president of the tribe, and they generally will have the authority to administer the programs and services for the community and the tribal government. Your executive branch may also have some veto power over some of the laws and statutes or policies that might be adopted by the legislative branch. And then finally, you've got your third branch, which is your judicial branch, which will have your tribal court system, and then the ability to hear cases, but then also if there's disputes and challenges to statutes and authorities, those can be seen in the tribal courts. Another style of tribal government, which seeks to mirror the traditional forms of government, adopt a general council style. So the general council is viewed as the entire community. And one thing that these tribal governments have done is host larger community meetings. Those may be an annual meeting, perhaps it's a smaller community and they're able to do quarterly meetings, but it's a meeting that's announced to the entire tribal community and they're invited to come participate. And at that meeting, the general council is comprised of all the members and they will vote on actions that will impact the tribe. There may be the passing and approving of laws, maybe an approval of certain expenditures, but the authority for that tribal government stems from the general council. And within the general council, then they will vote for an executive council. An executive council is going to be similar to your tribal council, where it's going to be a board who will be in charge of administering the day-to-day functions for the tribe. And so then under that structure, you have your departments that administer your programs and services reporting to your executive council. So now we've seen a little bit about how tribal governments are set up. And we talked about how tribes retain their inherent sovereign authority. So tribes have also retained civil, regulatory, and adjudicatory jurisdiction. They also have, I mentioned before, criminal law is fairly complex. Tribes do have some concurrent criminal jurisdiction. And if that interests you, I encourage you to go do some additional research and learn more about criminal law in Indian country. And then I mentioned Public Law 280 transferred some of that criminal jurisdiction to the state from the federal government. And you've seen that in Wisconsin and Minnesota. Now, for civil jurisdiction, tribes, again, their jurisdiction exists. They have the inherent sovereign authority to regulate over their own tribal members, and that's also been viewed to exist over non-member Indians within their community. So the location of the event or issue has to be within Indian country and within their tribal community. And then generally the tribe will have jurisdiction over that issue. There have been a multitude of Supreme Court and lower court cases which have examined the nuances of the jurisdictional issues within Indian country, both civil and criminal. Some cases have upheld aspects of civil jurisdiction, and some have also chipped away at some of the tribe's full sovereign authority. So one of the major cases that outlined jurisdiction, civil jurisdiction in Indian country was the Montana case. And that looked at regulatory and adjudicative jurisdiction over non-Indians on fee land. So in the situation there is an individual who is not a member of that specific tribe or a member of any Indian tribe. And they are doing some sort of activity on tribal lands. So the Montana case found that if this non-Indian is on tribal lands and entering into consensual relationships with the tribe or members through commercial dealings, then they would be subject to the tribe's civil jurisdiction. And that's most often seen when tribes enter into contracts with other business entities, or if non-Indians are entering into leases or other transactions on Indian country. Those issues will generally go to tribal court, and the tribe will generally have regulatory authority over that type of activity. The other area where tribal jurisdiction over non-Indians would exist is when the activity on the fee land within the reservation is an activity that threatens or has a direct effect on the political integrity, economic security, or health or welfare of a tribe. And so the courts have found that the tribes do retain the authority to regulate in those areas if it's going to have one of those major impacts on the tribe's community, safety, health, and welfare. Next, we'll look at jurisdiction and when a case would be going to federal court. So federal court jurisdiction is not an absolute jurisdiction over any issue that arises. There has to be personal and subject matter jurisdiction for a case to be brought in federal court. And some of the ways of getting that jurisdiction is through federal question, where if your issue arises under federal law and you're challenging some aspect of that, a federal court will have jurisdiction. Also, an area or an issue called diversity of citizenship. If you have, you'll typically see this with, if there's a dispute from people from different states or businesses from different states, that is considered diversity of citizenship. And generally tribes do not necessarily have that diversity of citizenship. So that's not always going to be an absolute way for a tribe to get into federal court. Another requirement is the amount in controversy. I believe it's about $75,000 that you must have a dispute that's going to arise to a certain value in order to be in federal court. But federal courts do require an exhaustion of tribal court remedies before the court will hear the case. So that means if there is an issue that arises and it could possibly be within the jurisdiction of the tribal court, the federal court is going to require that that case be brought in tribal court, and that the tribal court examines the extent of its jurisdictional authority before the case will be brought to the federal court for them to see whether or not jurisdiction was proper in tribal court or should have been in federal court. And so that's the exhaustion doctrine. Now, for state court jurisdiction, again, tribes are on a federal government-to-government relationship with the United States. And it's not an equal relationship then with states. And so, again, states generally lack jurisdiction over Indian country. But if there is an issue that arises outside of Indian country, generally that will be within the state court's jurisdiction, and a case will be able to be brought in state court. Some state courts do acknowledge a tribal exhaustion. So again, if there's a question about whether the matter should be brought in tribal court or state court, the state court may stay the case and request that the tribal court review the matter and determine jurisdiction before they would then hear the case. And there may be areas where state court jurisdiction is limited or has been preempted by federal law. In those cases, there are congressional acts that have been passed which have identified when state court jurisdiction exists or when something should be going specifically to federal court or tribal court. Again, the Violence Against Women Act specifically granted tribal courts or recognized tribal courts jurisdiction to address issues of domestic violence within their communities. One of the other things to consider about jurisdiction is, again, that Montana test. And if the action was a consensual relationship with the tribe, then again, that will go to tribal court. If it wasn't a consensual relationship within the tribal community, then that action may occur, that case may be brought in state court. Also, that second part of the Montana test, if the activity is going to be a threat to the political integrity, economic security, health, or welfare of the tribe, it's in tribal court. But if the courts find that it is not something that is having a direct impact on the health or welfare of the tribe, then the courts may say that case needs to be brought in state court. Other times when state court may have jurisdiction, maybe when the parties select it. You may see that tribes in business dealings with other businesses may select alternative dispute resolution. Maybe they'll select mediation or arbitration and may select different forums. They then may also choose to have disputes resolved and select state court as the forum to bring any cases that the parties may litigate. So there may be situations where there's agreements in place that would select state court, and in those situations, then those issues would be litigated in state court and not tribal court. Now, tribes being sovereign entities have their own unique political status. Tribes generally enjoy sovereign immunity, which is going to protect them from being named as a defendant in court. And this concept has been upheld. One of the more recent cases was Michigan v. Bay Mills Indian Community, which recognized that tribes and their instrumentalities retain sovereign immunity from suit and legal process. And so again, then in that situation, there was a dispute related to gaming issues with the Bay Mills Indian Community and state of Michigan. And some other entities tried to file suit, and Bay Mills was found to be protected by their sovereign immunity and not subject to the litigation. Sovereign immunity can be waived by the tribe, though, and Congress has found that when a tribe is going to be waiving their sovereign immunity, it has to be a clear, express, unequivocal waiver. And so tribes have done this by either through terms in their constitution, which outline when and how sovereign immunity can be waived. They've also done it through tribal code and passed tribal legislations that identify when and how a tribe's sovereign immunity can be waived, and if there's any limitations on the waiver or conditions that must be included. And this sovereign immunity also extends to tribes and their businesses and their business entities. They also have and enjoy the tribe's inherent sovereign immunity. And with that, those tribal businesses also have the ability to waive the immunity of that business. And again, you might see that in tribal resolutions or in the business entities resolutions or the business entities contract terms. Those entities, however, do not have the authority to waive the immunity of the tribe. Generally, that is going to be reserved and would be beyond the scope of the authority of that business entity. So now let's talk a little bit about real estate within Indian country. And Indian country has been defined in the U.S. Criminal Code. And in there, they've defined Indian country as all land within the exterior boundaries of an Indian reservation, dependent Indian communities, and Indian allotments where the titles have not been extinguished. So you see that defined in the criminal code, but that definition has been picked up in many civil cases, and this definition of Indian country is the generally accepted definition that applies to most matters. So the tribal real estate within Indian country can be comprised of reservation land within the reservation boundaries and trust and fee land. And now, again, we talked about earlier, that reservations were created first through treaties, where there was specific language in the treaties that set aside a tract of land. Here we've got some language from a treaty with the Chippewa, which identified a land. In some treaties, it just identified that a tract of land would be set aside and further identified. And in those situations, then an executive order was issued, and that executive order often then identified the reservation boundaries. That's a situation that happened with Le Coudray. The treaty reserved a tract of land to be further defined, and then an executive order was later issued, which gave a legal description for the boundaries of the reservation. Other ways reservations were created was through congressional acts. There were congressional acts which then set aside lands for tribal communities. Congressional acts were also used to create trust lands. We saw that with, again, the General Allotment Act and also called the Dawes Act. In Minnesota, there was a specific act called the Nelson Act, which allowed for allotment of specific tribal reservations here in Minnesota. But these congressional acts provided for the sale of certain federal Indian lands, and they might have, there's various methods that were used. And so in some of these congressional acts, they also allowed for the identification and selection of other lands. This would have been the case with the allotments. Finally, within Indian country, you may find tribal and individual Indian land that's acquired in fee simple. Tribes are on a current policy to, a lot of tribes are currently trying to build back up their reservation land base. And so they're out acquiring land on the free market, and so they own land in fee simple. Same with several individual tribal members just out purchasing their own home or their own business and need some land to live on or to operate their business from, and so they purchase land in fee simple. And those lands within reservations would be considered Indian land. You also see tribes owning lands and individual allotments outside of reservation land too. So a little more about allotments. Again, I just mentioned that they're created through the Dawes Act, General Allotment Act, and there are different types of allotments. Generally, when they were created, they were for a term of 25 years. And they could have been as a trust allotment held in trust by the U.S. for the benefit of the individual. And some of them were restricted fee allotments. So there was a fee type of title, but there was restrictions on alienation that were incorporated with that title. And after they were found that the General Allotment Act was not working and this allotment policy was not working, then there was legislation that passed which extended the allotment period or the trust period from 25 years and extended it indefinitely. And so that's where you'll still have some allotments that exist today. There's another type of allotment considered a script allotment. And in that situation, there were individuals were told that they could select an allotment, and they were given a script, which was like a certificate or a document that allowed them to select their land at a later date. And so tribal members had then turned those scripts in to select their purchase or their land bases for their individual allotment. There are some unique issues that do arise with allotments. Some of the allotments then did have the removal of some of those restrictions, and during that allotment period and thereafter, you saw that great reduction of tribal land ownership. Once some of those restrictions were removed, then those fee lands were then sold to outside of tribal ownership. There's cases where they were sold at a greatly devalued rate. Other times, the U.S. government would force the sale of some of those allotments. You'll find there will be deeds in historic records where they're considered a non-competent Indian deed. And so a tribal member was going to sell their land. They weren't considered a competent individual to engage in this transaction. The Bureau of Indian Affairs was involved, and it was the transaction was brought to the BIA for review and approval, and then the transaction was agreed upon by the Bureau and signed off on, and so the land was sold. Other times, the Bureau of Indian Affairs negotiated for the sale of Indian lands and then were forced to give fee patents to those individuals. So another issue that has come up with allotments is when the holder of the allotment does pass away and the land is then inherited. Prior to, or if the tribal member does not have a will identifying how that was going to pass, you would then see allotments that would pass to the heirs, and they would all have a fractionated interest in the allotment. And as this happens generation after generation, then you ended up with an allotment that could have, there's some out there that have hundreds of individuals that have an interest in this allotment. And when you get to that point, it's a practical matter of how to manage it when you have so many people with an interest trying to decide what to happen with that land. So those are one of the issues that you'll see that's coming up was through the inheritance of allotments. So with the different types of tenure in Indian country and the different mechanisms for holding real estate, there's a variety of different places that you'll need to go to do your real estate transactions. If it's trust property, for instance, where you would go to record your land, trust property would be recorded within the federal system because the trust land is under federal regulatory jurisdiction. And so those documents will be at the Land Title and Records Office. And you would also need to work with the Bureau of Indian Affairs on those transactions because in order to fulfill the trust responsibility, the BIA has been delegated the duty to review and manage and approve of those transactions on the trust land. So for tribal trust land and individual trust land, you'll be going through a federal system and recording at the Land Title and Records Office. If it's fee land, then you'll be going to the county recording system and having your documents recorded there. Now, again, tribes are on an era of self-determination, and some of them are establishing fairly sophisticated real estate departments. And within their real estate department, they may have their own system of recording and managing files. So if you have land within a reservation or maybe adjacent to, but any land that might be owned by the tribe in fee simple, those documents might be required to be recorded at the county, but perhaps you also have to record some of those documents at tribal real estate department. Similar for some of those trust documents that might be related to activity on tribal trust land, it would be required to be recorded in the federal system, but the tribal recording office may want to keep their own files and keep documents as well. And then for personal property, again, you'd be looking to the Secretary of State for personal property recording, but the tribal office might have a place of recording personal property. And these issues could come up with some mobile homes and other temporary structures such as that as to where they're going to be titled and who's going to be tracking the transfer of title. So again, like I mentioned, another thing to consider is who has the authority or the duty to review and approve those documents. On tribal land, the tribe is most likely going to want to play a role in reviewing documents related to their real estate. But again, those will also be sent to the Bureau of Indian Affairs to be reviewed under the regulatory systems, regulations in place regarding federal Indian land. So the BIA will take that review and approval process before submitting those documents to the Land Titles and Records Office. And then for individual trust land, again, the BIA would be involved in that review and approval. And within the legal framework, you'll find a lot of the legislation related to Indian law and tribal communities in Title 25 of the Congressional 25 United States Code, and then similar into the CFR, Code of Federal Regulations, 25 is set up and has a variety of different regulations related to issues within Indian country. And so there is a substantial amount of regulatory federal authority in 25 CFR. There may be federal codes to look at, there may be federal regulations, and then BIA involvement. But then you also look, the tribe may have enacted their own codes, which would identify what regulations apply to land transactions on tribal lands. So you'll always want to be sure to check with the tribe. And then again, back to the jurisdictional piece we were talking about, how title is held in that tribe or in that land is going to be determinative of which court you may end up in. Again, trust land is going to be in federal jurisdiction. Fee land generally would be in state court jurisdiction. Lands within reservations may be in tribal court jurisdiction. So you have to take that into consideration as well when dealing with Indian lands. Some of the other regulatory issues that may come up on transactions in Indian country are, there's a variety of different regulatory matters where tribes are now exercising their sovereign authority. This often comes up in business transactions and construction issues. So there may be a tribal employment rights ordinance and a TARO office set up, and if you're going to be doing construction work on Indian land, then you may need to check in with the tribe's TARO office about what employment rights will be applicable to the work on that land. If you're doing transactions, business transactions within a tribal community, you may have to check and see if you're required to obtain a business license from the tribe in order to do transactions. Again, for gaming issues, there's a large area of legislation related to, from the Indian Gaming Regulatory Act and related to that regulation. So your work may involve that area, and there may be tribal regulation associated with that. Also looking at taxation. Is there tax issues related to the work you're doing? And building permits. Does the tribe have a permit system and a officer who will be coming out and doing inspections to see that there's been compliance with a tribal building code? Things to think about there. And some other big issues that you may come across, especially if you are doing any development and disturbing the ground, is working with the Tribal Historic Preservation Office to make sure that you are not going to be disturbing any cultural and historic areas of the land. They will know where there are possible burials and where there have been lands that have been designated as protected areas. And so you'll need to be sure to communicate with the Tribal Historic Preservation Office. There's also, if you are doing some digging and you come into an inadvertent discovery of remains, human remains, the Native American Graves Protection and Repatriation Act may apply. And so whenever you're going to be disturbing the ground, it's wise to work closely with the Tribal Historic Preservation Office. Even if you're disturbing the ground in an area that has previously had development, because that development may have been done at a time where some of these regulations didn't exist or were not complied with. In Fond du Lac, Minnesota, there was some work that was being done on, I think, a local county road or highway. And it was improvement works. The road had existed, but when they started digging into the ground, they found human remains and realized that when the original road was in place, some of these issues weren't addressed, and but now they did need to comply with NAGPRA and protection of human remains. And so those things may come up even if there has been prior development. You just have to keep it in mind and work closely with the tribe. Tribal real estate transactions can also be affected by some of those federal Indian law acts that we talked about. When you're looking at transactions with fee land, one issue that we've come across is the Anti-Deficiency Act. It's a piece of historic federal legislation which did not allow for federal action on land for any federal action without an appropriation of funds. And so we've seen that come up on transfers of fee to trust of tribal land. If there's anything in title which could then impact and cause a financial obligation to the federal government, they will want that to be done, to be removed from title. So for instance, if there is any maintenance agreements on property, perhaps there was an encumbrance on the property to maintain hiking trails or paths by the owner. Well, if that property were then to go to transfer into trust, it places that obligation to maintain those trails on the federal government, and there isn't a specific appropriation of funds for that piece of land. So the federal government would require that obligation to be removed from the land before taking it into trust. There may also be environmental easements and tribal zoning or cultural zones that may impact some of the work that's being done on the land. Also look for some co-management issues. Again, if there's an agreement to maintain trails and park system between two parties, sometimes those, and for future transfers too, sometimes those might be best not recorded as an easement, but as a side agreement between the specific entities so that you don't have issues clouding your title later. And again, you've got the federal legislation I mentioned earlier, the Non-Intercourse Act, which limits tribes from conveying property unless there is approval by the Bureau of Indian Affairs. So this has most specifically been reviewed in that a tribe can't transfer its trust lands without approval from the Bureau of Indian Affairs. And that includes any conveyance. So what you'll see also is leasings and rights of way of federal Indian lands. But what hasn't been as clear is tribal fee land and whether tribal fee land has been impacted by the Non-Intercourse Act. You may run into situations where a tribe is looking to transfer do a transaction with its fee land, and a business entity might be concerned about violating the Non-Intercourse Act and have concerns about moving forward with the transaction. So there's also, again, 25 CFR has federal regulations related to the transfer of Indian land, the management of Indian land, leasing, rights of way, and some of the speakers are going to get further into specific issues about rights of way across Indian land. But that's where you'll be able to find a lot of the principles which will impact your transactions. But again, I just wanted to go back to some of those founding principles. And here's a quote from Marge Anderson, and I think it's worth hearing and to take into consideration and just mull over as you're dealing with tribal communities and Indigenous people. When Indian incomes are level with yours, when our schools are as good as yours, our houses as warm, our kids as safe, and our woods and streams as clean as yours, when our babies first open their eyes to as bright a future as yours, then we'll talk about level playing fields. Whether out of greed or out of racism or out of ignorance, there are always some who will go after Indian self-determination and economic development in ways as old as Columbus, as bold as Custer, and as devious as any federal land grabber. So I hope you learned something. It's a lot of material. Please reference your handouts if you have any questions. I'm available, and I believe we do have some other panelists who are here to answer questions. Thank you for your time and attention.